Hello, everybody. This is my first webinar, but I've spoken a lot. Just a little bit about myself. I'm one of the attorneys at Bugbee & Conkle. I've been with the firm for almost 13 years next week, and about 90% of my practice is workers' compensation. I dabble in a few other things. Large majority of that is taking administrative hearings, so workers' compensation hearings. Today, I'm going to talk about workers' compensation basics. This is really a presentation for beginners. So if you have been in the workers' comp world for a while, a lot of this might be repeat, but you'll probably still learn a thing or two new. I'd like to take questions as we go. So if you have a question, go ahead and ask it, and I'll stop and try to answer that as we go along. So I'm going to start, and most of the presentation is just going to be reviewing some basic concepts in workers' comp, defining things, different kinds of compensation. So to start from the beginning, there's two types of employers in Ohio workers' comp. They're self-insured and state-funded. So most employers are going to be state-funded. The larger employers are self-insured. In state-funded, it works like traditional insurance. The company pays into an insurance fund, and the bills are paid by the Ohio Bureau of Workers' Compensation. In self-insured, the company pays for all the bills outright. And then there's a difference for the way we process claims as well. For state-funded, the Ohio Bureau of Workers' Compensation will make initial decisions, and either side can appeal the decisions and have a hearing with the Industrial Commission, and I'll talk about that a little more later in the presentation. For self-insured claims, the self-insured employer is the one to make initial decisions, and the claimants can appeal if they don't like the decision. So self-insured employers have a little more control over the claims, and then they pay dollar for dollar rather than have insurance rates go up and down. Okay, so the first thing we have to do for workers' compensation is define what's an injury. And the reason why we want to know what is an injury is injuries are compensable or covered under Ohio workers' compensation. More complicated than you would think. Here's the official definition. It's any injury, and this is under the code, caused by external accidental means or accidental in character and result, received in the course of employment, and arising out of employment. And I'll break that down a little bit for you. So in the course of employment means injury sustained while performing a required duty in the employer's service. And this refers to the time, place, and circumstance of the injury. So what we're talking about here is usually whether the person is actually at work. An injury occurs in the workplace and while they're working. So, for example, if a person is on break and leaves to go to McDonald's and is injured at McDonald's, that's not in the course of employment. They're not actually working. They're not at the workplace. Arising out of employment requires a causal connection between the injury and the employment. And what we're talking about here is whether the event at work actually caused the injury. So if a person has something like a herniated disc in their back, did that arise out of employment? Even if there was an event that happened at work, you have to show that that actual condition arose out of the employment or was approximately caused by the employment. So every injury needs to arise out of employment and be causally related, that is causally related, arise out of employment and be in the course and scope of employment. So many things are an injury that it's easier to talk about what is not an injury when defining what is compensable in Ohio. The first thing I have here is psychiatric conditions. In Ohio, and this is different in other states, you can't have a standalone psychiatric condition. So the classic example is if the employer is a gas station or a bank and they get robbed, your employee isn't hurt, but they suffer some kind of PTSD or anxiety as a result of the incident. That is not covered under Ohio. That's not a good workers' comp claim. They have to have a physical injury, and the psychiatric condition has to come from that physical injury. So it has to be something more like they were assaulted in the course of the robbery, and as a result of that, they develop some kind of psychological condition. Often it's depression. You can have a standalone psychological condition. The second thing on the list here is an injury or disability primarily caused by the natural deterioration of tissue. This is something usually caused by the aging process. So this sort of the example I was giving earlier, if your employee is picking something up and they hurt their back, they might have a back strain as a result of lifting something at work. Let's say they have a herniated disc. Sometimes there's a fight about whether that herniated disc was actually caused by the event when they were lifting something, or was it caused by the natural deterioration of tissue? Was this something just related to the aging process, or maybe something pre-existing? That is something that's not covered under Ohio workers' compensation law, and that represents a lot of the disputes we have, because you need doctors to tell us what the answer is, and a lot of times there's disputes between doctors, and it's not always real clear-cut. Third one, injury received in employer-sponsored recreation or fitness activity if a waiver is signed in advance. This refers to if you have a company picnic or maybe a company softball league, or when I was in college, I worked at a plant that had a gym inside the facility. If your employees are injured in any of those activities, it could be compensable unless you have them sign a waiver. There's a form that the Ohio Bureau of Workers' Compensation puts out. The employee should sign it before they begin participation, has to be before, and if they're hurt, then that's not covered under workers' compensation. More of what's not an injury. Injury approximately caused by intoxication, employee under the influence of a controlled substance not prescribed by a physician. This is something I could talk about for the entire hour, and I have a little bit on this at the end of the presentation if we have enough time. But in a nutshell, if the cause of the injury was your employee being drunk or under the influence of a drug they don't have a prescription for, and not the workplace, then that is not covered. So for example, I had a case once where a claimant was driving a forklift and ran right into a pole, tested positive for cocaine. If we can show, we have medical evidence that the reason why they ran right into this pole is because they were impaired due to the cocaine, then it shouldn't be a covered injury. It's not compensable under Ohio workers' compensation. If, on the other hand, the person was not impaired and was just being stupid, we have to pay for that. If they just run into a pole for no reason, that is compensable. People do dumb things, you still have to pay for those. Idiopathic injuries are injuries personal to the claimant. And the classic example of that is if you have an employee just walking, usually walking on the premises. Sometimes it's stairs, climbing up and down stairs. They have a prior bad knee, and this person slips for no reason. They're not doing anything. They're not doing anything other than walking or normal activities, climbing stairs, and a pre-existing condition causes them to fall and get injured. That's not going to be compensable either. The rule in that case is the claimant has to rule out idiopathic causes. So it's the job of the claimant to prove that they don't have a pre-existing condition that contributed to their injury. Those are kind of funny cases. If the person's carrying something for work, a lot of times the thing they're carrying will cause it to be compensable because now they're doing something work-related, they're carrying something for work. Sometimes they're falling and they're just walking and they fall, but if they fall on something in the workplace, especially if you're on a factory floor and there's something they hit their head on, then it's going to be compensable because there was a hazard in the workplace that caused the injury. People are just clowning around, that's not going to be covered under workers' compensation. Fights also go in this category if people are fighting. I'm going to talk about that a little later in the presentation. Generally, if you're an innocent victim of horseplay, somebody's playing a prank on you, usually that's going to be covered, but if they're both participating in something like that, then it's not going to be covered. Purposely self-inflicted injuries, you don't see these very often, but if somebody purposely harms themselves, then that's not covered under workers' compensation if you can prove it. That's why the original definition had the word accidental in nature. It can't be purposeful. Injuries included while coming or going to work. This is kind of a bigger topic as well, but generally, if a person is a fixed situs employee, so they have one fixed place of employment, while they're coming to or from their place of business, they're in an auto accident, that's not going to be covered. There's different nuances to that, though. Generally, the parking lot is going to be compensable if it's controlled by the employer. I had a case once where the employee worked for a cleaning company, and she was going into a building and tripped on a sprinkler head in the lawn right in front of the entrance. But that wasn't compensable because her employer, there's a technicality in the law, her employer didn't own that didn't own the building actually. They were just cleaning it. They were just contracted out to clean it. So they weren't in control of the ingress or the egress. And under the coming and going rule, the commission found that wasn't compensable. If she had been going into her office building, owned and controlled by the company, then that would have been compensable. If your employee works at the mall and the parking lot is not owned by the individual store and it's owned by the building, that's not going to be compensable. So there's a lot of nuances in that. You should check with an attorney before allowing something like that. Another issue is if you have a traveling salesperson, their whole job is driving. That's anytime they drive in between locations, that's probably going to be compensable. When I travel to take hearings, that's going to be compensable, even though I have a fixed office when I'm going off-site and driving, that's part of my work. And it gets a little messier if you have somebody that's sometimes traveling. Question. All right, it gets a little messy when you have somebody that travels to different stores to set up displays or do things like that. Some jurisdictions have found that is compensable, and others have found they're not doing their job duties when they're in their car between stores, and it's not. Okay, so they weren't on break, and the headphones, this is a question. They weren't on break, and the headphones were for personal usage to listen to music. Is this compensable? Oh, I'm sorry, I gotta read the whole thing. I'm new. All right, came across injuries that happen in the parking lot during an unauthorized break. They go to their car to get headphones and slip on ice in the parking lot. Okay, good question. All right, so I would argue that this is a question. The person is supposed to be at work. They're not authorized to, but they go out to their car to get something, slip and fall on ice and hurt themselves. I would argue that they've deviated from their employment. They're not in the course of their employment because they're not doing anything for their employer. In fact, they're doing something they're not supposed to do. They're going outside of their workplace into the parking lot. Did it arise out of employment? It's not really causally connected to their work, although it is connected to something that happened at the workplace and they're on the premises. So this can be questionable. Generally for breaks, if it's a paid for authorized break and they're on the premises, it's going to be paid for. Generally, if they go off-site to a restaurant or something like that, it's not going to be paid for. This, I think, is iffy, but probably I would fight it and argue that they deviated from their employment and it shouldn't be paid for. And I think you have a pretty good argument there, especially since they weren't doing what they were supposed to do. Good question. All right, pre-existing conditions unless they're aggravated. This is another one of those topics I could probably spend the whole hour on, aggravation. Good example is a lot of people come into the workplace with bad backs. So if somebody has a pre-existing herniated disc or degenerative disc disease, that's not paid for under workers' comp because they had it before they showed up, unless it was aggravated. And before 2006, the law was symptomatic aggravation. So a person would only need to prove that they hurt more after the injury than they did the day before the injury, which is a pretty easy standard. Just come to the hearing, say it hurts worse. The employer's on the hook for their back forever. And so they tightened that up in 2006 and made it substantial aggravation, which has made it better for the employer, but has made it a little more confusing. For substantial aggravation, you have to show a worsening of the conditioning, and it has to be more than just, I hurt worse now. You have to have some kind of objective evidence to prove that. So diagnostic, clinical, objective findings. The gold standard, of course, is if you have an MRI before and an MRI after, and you can show a progression of the degenerative disc disease or something different, that's a really easy way to show substantial aggravation. But sometimes you don't have those things. Your doctor can look at your MRI and know that this pre-existed, it looks old, but not have a pre-existing diagnostic testing to really show the difference, the progression. So they use other things like range of motion testing or other objective testing to show substantial aggravation, which has made it a little harder for claimants to get these conditions in, a little better for the employer. The other newer thing about the law, and the law is now 12 years old, but we still see the old claims. The other thing about substantial aggravation is there's a provision in the law that says once that condition has returned to what it would have been, the level it would have been if it had not been for the injury. A lot of people call this baseline, but it's really, if you look at the law, the language says it has to be where it would have been had it not been for the injury. So it does not have to be at the level it was before the injury, just where it would have been with natural progression. Then you can get compensation and medical stopped in the claim for that particular condition. That's sort of more of an advanced topic, but a lot of people call that baseline. Another question. Okay, another question. If an accident happened between the commute between two campuses, she drives from her car from one campus to the office at another campus, is that compensable? That is a good question too. That actually kind of comes down to whether she's paid during that commute. If you're an hourly employee and you're paid hourly, or if you're paid mileage, most courts, and you know, most of these things are administrative hearings, but we have to look to the courts to tell us what the law is. Most courts are going to find that is compensable, but it's a little in flux now because the jurisdictions are finding different things. But generally, if they're paid for that commute between locations, that will be a good workers' compensation claim. If you have somebody, and I find this a lot with home health aides, that once they get to a location, they're on the clock and they do their job for 2 hours or whatever it is, and then when they're done, they're off the clock, they're not getting paid while they go to the next customer. That kind of thing is not going to be compensable. But if they're paid a solid 8 hours for the travel in the different locations, generally that will be compensable. Unless, and you want to look at these, at their route, where they're actually injured, because if they go off course, say they're running home to pick somebody up, or they stop at Walmart, or they're going to get lunch, that's a deviation, and that should not be compensable. You can look at those. A couple more questions here. Okay, question is, what about if salaried employee? I actually haven't seen much case law on that. I think that's kind of a gray area. But if I had to guess, especially in Toledo, where the hearing officers are pretty liberal, I would say that's going to be a paid claim if part of the job is to go between locations. Because in Ohio, there's a provision that says the law is to be liberally construed in favor of the claimants. So they're going to give the claimants every benefit of the doubt. So I would guess that is going to be compensable. You're going home from the airport due to a business trip and are injured. Another good question. Home from the airport. You know, I would say that definitely to and from a seminar or work where your employer sent you is going to be payable. So coming from the airport, I would think that would be payable as well. At a point, you're going to get too far removed, but I think that would be payable. So for example, if you were actually injured on the airplane, that might be too far removed. There's been some case law about like over-the-road truck drivers who stay in a hotel, and courts have found with very similar facts, different outcomes. There was a case where a guy was injured in the parking lot. He parked in the parking lot, he was going to stay in the hotel, he was a truck driver. And I believe that one was compensable, but another case from a different district where the guy fell in the shower at his hotel was not compensable. So it kind of depends. Sometimes there's no rhyme or reason. You have to really look at the facts on this and find out how closely it is related to the actual work activity. I would think coming home from the airport would be compensable. But look at it and did they stay 2 extra days in wherever they were for pleasure, or did they come right back? You have to look at factors like that. Did they come right home? Did they deviate in any way? Conditions that are compensable under Ohio workers' comp are either injuries or occupational diseases. The vast majority are going to be injuries, and those are the easier ones. But we also have occupational diseases. This is the official definition. I have to be honest, it's really hard to tell what this means. A disease contracted in the course of employment, that's the easy one. Employment creates hazard distinct from employment in general. Employment creates risk of contracting disease in a greater degree and a different manner from general public. So if you look at the things that are occupational diseases, it kind of helps understand the definition a little better. Asbestosis is the classic one, or some disease you get from asbestos exposure. The employment creates a hazard of contracting asbestosis distinct from employment in general. Not every job is going to cause asbestosis. It's because of the exposure. And you can say the same thing for silicosis or any kind of exposure to dust. The employment creates a risk of contracting the disease in a greater degree in a different manner from general public, the same thing there. But if you look at something like heart attacks, and I think I have this later in the presentation as well, the rule for a heart attack is if the heart attack is due to stress, work-related stress, it has to be a greater stress than the public is usually, than a person would be exposed to at work. It has to be a very large amount of stress because the courts say everybody is exposed to stress at work. Not everybody is exposed to silica or asbestos, those kind of things. There's a little gray area, other things that sometimes can be occupational diseases or things like carpal tunnel syndrome. People sometimes argue those are diseases. And the reason is really there's a better statute of limitations for occupational diseases. For an injury, you have to file a claim within 2 years. No, I'm sorry, it's 1 year now. We just changed this. 1 year as of September. It was 2 years for years and years. It's the same for occupational diseases, but it's 1 year from the date of diagnosis, treatment, or disability. So something like asbestosis or lung cancer due to exposure to asbestos has a really long statute of limitations because statute of limitations doesn't run until 1 year after the person is disabled, which means they're off work. So you can see how if you had something like carpal tunnel syndrome, you'd want it to be an occupational disease because there's no statute of limitations until you're off of work for it. That's why we even deal with the definition of occupational disease. A lot of times you're trying to prove something is an occupational disease in order to give you a longer statute of limitations. Okay, so I'm going to just talk about the different kinds of compensation. Temporary total disability compensation, a lot of times we refer to this as TT or TTD. And temporary total is an inability to perform your job at the time of your injury, or it's unable to return to your former position of employment. It doesn't mean that you're not able to perform any work. It means you can't work the job you were working when you're injured. And so temporary total is payable when a person is off work due to their workers' compensation claim and is often the costliest part of your claim. So it has to be due to the injury-related impairment. When you have allowed workers' compensation claim, the claim is allowed for certain conditions, which is kind of a strange concept at first. You don't allow a claim, I have an allowed workers' compensation claim for my back. It's not for a body part, it's for specific conditions. So it's allowed for a lumbar strain, a thoracic strain, and a herniated disc at a specific location. question is this person off work solely due to those allowed conditions? There has to be a reasonable expectation of improvement. That's why we call it temporary total. Has to be something that is likely to get better for the person to receive temporary total. Talk a little bit about compensation rates. Temporary total is based on the first 12 weeks of temporary total are based on the claimant's full weekly wage. And full weekly wage is the highest of their last week of employment before they were injured, or an average of the 6 weeks before they were injured. And everything after that, temporary total is based on average weekly wage, which you take the 52 weeks they worked before they were injured, add them up and divide them, average them, and that's the average weekly wage. I couldn't tell you why they separate that, why you get paid full for 12 and average for the rest. That's just what they do. There's a state maximum. The highest you can get paid in for a 2018 injury is $932. It goes up a little bit every year. So a person who was injured in 2016 will have a lower rate. So if you're injured in 2018 and you're still on temporary total in 2020, that's still going to be the max you're paid. It goes by the date of injury. And I should say it's temporary total is paid at 66 2/3 of your average weekly wage. It's not taxable, and that's why they cut it off like that. So you can see how it costs the company a lot of money. Is overtime included in income that I report to workers' comp? Overtime is a good question. I believe overtime is included in the average weekly wage. Think for a second. Yes, overtime should be included in the average weekly wage. There's a different question for overtime for wage loss, and I'll touch on that because that's coming up pretty soon. But yes, include the overtime. Don't include vacations. Only time for actual paid work. So how many weeks of temporary total can a claimant get? And the answer is there is no limit. My worst case, I had a guy with bilateral carpal tunnel syndrome who got 10 years of temporary total. Because there are 4 ways to terminate temporary total, and if they don't meet one of the 4, then they can keep receiving it. The first one is they return to work. You can't work and receive temporary total at the same time. They return to work anywhere, even if it's a part-time job, temporary total is terminated. Second one is their doctor basically says they can return to work, returns them. Even if they don't physically come back to their job or go to a different job, temporary total should be terminated. Claimant has reached maximum medical improvement. I've got another slide on this and I'll explain it more in a second. But basically, they're as good as they're going to get. They're not improving any longer. Claimant's treating physician has given him or her restrictions, and claimant was offered work within those restrictions. So in order to receive temporary total, there's 2 forms the claimant is required to fill out. The claimant fills out something called a C-84. That's the request for temporary total. And the main purpose of that is for the claimant to say, to certify that they're not currently working and they're not, what kind of benefits they're receiving. The claimant has to swear that they're not working somewhere else to get temporary total. The other one, though, is the Medco 14. This is filled out by the physician. The physician, among other things, will say whether the person needs to be completely off work or whether there's just restrictions. So if the doctor gives them restrictions, let's say your employee works in a factory and the doctor says they can do seated work only and they can't lift more than 10 pounds. Well, if you look at those restrictions and they can't return to their former job with those restrictions, then they would be entitled to temporary total. Even though the doctor's saying they could do some jobs, they still can't return to their former position unless the doctor gives restrictions and the company has a job they could offer them within those restrictions. So they can't return to their former position, but the employer says, I looked at these restrictions and I do have something you can do. You can sit and sort papers or whatever. Then there is a way to get the claimant off of temporary total using those restrictions the employer has to, I think I have a little slide on this actually, has to give them a good faith job offer, and there's details, there's specific rules for this in the code. And as I said before, especially in the Toledo office, the commission tries to give the employee the benefit if it's 50-50. So the employer has to make sure they really follow the rules on this. The job offer means a proposal made in good faith of suitable employment within a reasonable proximity of the injured worker's residence. It has to be in good faith. It can't be something given in order to cut off TT. So what do I mean by that? You give them something you know they don't want to do, or you offer them a job really far away, or maybe a shift that you know they're not going to do because of childcare, something like that. That's a bad faith job offer. And even if everything else is correct about the job offer, if the other side can prove to a hearing officer you made that offer in bad faith, it's not going to cut off their TT. Suitable employment has to be something kind of close to what they were doing, suitable for their restrictions, within a reasonable proximity of the injured worker's residence. Like I said, it has to be kind of close. So you can't offer somebody a job in a different state 100 miles away, expect them to take that job, and if they don't, temporary total is terminated. And another factor, as I kind of touched on, is the shift. You have somebody that normally works first shift. You try to offer them a third shift job, and you know they're a single parent and there's no way they can take it. That's not necessarily going to be a good faith offer. It has to be in writing, and it has to be based on restrictions given by the treating physician. It can't be based on restrictions by the company doctor. It has to be the treating physician. And it has to be very specific. You have to identify the position offered, include a description of the duties required, and clearly specify the physical demands of the job. So I look at a lot of these. A lot of companies will send a job offer, and it'll maybe say the title of the job, and then it'll say, and we won't give you any work outside your restrictions. That is not good enough. You have to specify very clearly exactly what they will be doing. And, you know, if the restriction is no lifting more than 10 pounds, say how much they'll be required to lift within that description. Because if the claimant rejects it and it's not specific, what we have to do is take it to a hearing. The company can file a motion to terminate TT based on the good faith job offer. The hearing officer decides whether it's a good faith job offer. And if the job is not exactly clear, they will reject it, and then you've got all that time they're still on TT. Yeah, so it's not enough to say a job will be offered within your restriction. Also make sure that when you send a written job offer, best practice is to send it both certified and regular mail, email if you can, and to give them a couple days. I see a lot of these where people send a job offer and say, I need you to be here in 3 days. And the claimant gets it after the job was to start, something like that. It's okay to call the person too. It's good practice to call them, tell them that this job offer is coming, but you should send it in writing just in case they don't actually show up. If you can, have your claimant sign it, showing that they actually received the job offer if you hand it to them in person. You only get into trouble when the claimant refuses to accept the job offer or refuses to come back. Another example of not good faith would be something like, an example I can think of is if you had somebody working in your location in an office or a power plant, something like that, and you tried to give them a job in the cafeteria or gas station or something they think is low level, that might not be good faith. If the reason you're doing it is they won't accept it, and to cut off TT, which is good faith is, you know, kind of hard to prove. Okay, maximum medical improvement. I said that this was one of the things that you can use to cut off temporary total disability compensation. If you can get a finding of MMI or maximum medical improvement, temporary total stopped, that means a treatment plateau at which no fundamental functional or physiological change can be expected within reasonable medical probability in spite of continuing medical or rehabilitative procedures. In a nutshell, that just means they're not going to get any better. This is as good as it gets. It doesn't mean they're cured or back to their pre-injury status. It just means that their progress has plateaued. MMI finding can come in different ways. If your treating doctor says they're at maximum medical improvement, that's the easiest. You can cut off TT right away. A lot of times, if it comes from a company doctor or a bureau doctor. So if your claimant is on temporary total, the company is entitled to a 90-day exam. Every 90 days, they can have claimant examined by their own doctor, or if you have a state-funded employer, you can ask the bureau to set up the exam, and they will sponsor the exam. And your own doctor gets to look at the person, look at the allowed conditions in the claim, and give an opinion as to whether they've reached maximum medical improvement. If you have a doctor that says they've reached maximum medical improvement, you can ask for a hearing. If there's a finding of maximum medical improvement, temporary total disability compensation will be cut off as of the date of the hearing. Really common misconception about MMI, though, it terminates TT, not treatment. Person can still get their treatment if they're at MMI. So we see that argued a lot, that they're MMI, and so therefore they shouldn't get their chiropractic. That's not true. If a claimant still benefits in some way, it keeps them in a static position, especially if it keeps them at work. Even though they're MMI, they're still going to get their treatment. Okay, so what happens if you have somebody that was injured and they're at maximum medical improvement, but they still can't return to work? So they can still have permanent restrictions. They've hurt their back bad enough, or their shoulder or something. They can no longer do your heavy-duty job where they're lifting. But they're at a treatment plateau and it's now permanent. They're no longer eligible for temporary total. Claimant can ask for something called wage loss. And wage loss is the inability to perform the duties of their former position due to the injury-related impairment, but they're at MMI. So there's two types of wage loss. If your claimant has returned to a light-duty job or a different job, but they're paid less, they can get working wage loss, which is the WWL there. Working wage loss happens when they get the difference between their what they're getting paid now and their TT rate, so their average weekly wage, 66 2/3. So it's a mechanism by which the employer or the Bureau of Workers' Compensation, if it's state funded, makes up the difference between what they're not making now due to wage loss. There's something called non-working wage loss, which means the person is unable to return to their former position of employment due to restrictions, and they're at maximum medical improvement, but they can't return to the former job. They have to show that they are making a good faith effort to look for work within their restrictions, haven't found it yet, and then they should be able to get non-working wage loss if they fulfill the requirements. This is actually pretty hard to get. You have to register with Ohio Job and Family Services. You have to spend a lot of time looking for jobs. You have to turn in sheets showing where you look for jobs, who you talk to, whether you had an interview. You have to really prove that you are out there looking for work. I've had one of the attorneys from Gallon and Tackus tell me, unless their claimant is very bright, they tell them not even to bother because there's so much that goes along with it. But we do see it, fairly frequently. As long as they follow the steps, they should. You can get 226 weeks total. That won't go on forever. Of course, the loss of wages has to be proximately caused by the injury-related impairment. You can't just have a claimant who decides they don't want to work as much, decide they want to work part-time. If their doctor hasn't given them restrictions that say they can only work part-time, then that's not proximately caused by the impairment. You can't have them decide on their own because of the injury. They don't want to do the job. They actually have to have restrictions. And this is meant to encourage the claimant to work, find another job, and return to work at the transitioning period. There's another question. Oh. Yes, wage loss is different from scheduled loss of use. I'm going to get to that scheduled loss pretty quickly here, I think. Scheduled loss is loss of a body part or use of a body part. And this slide here, I'll talk about that. So first, there's permanent partial disability. There's two different kinds of permanent partial disability. The most common one is It's like a damages award for personal injury. Compensation for percentage of permanent partial impairment sustained as a result of an allowed injury. Technically, this is supposed to be what percentage is the claimant permanently impaired as a result of their injury. So they have a herniated disc. What percentage are they permanently impaired as a result of that? And they get a little chunk of money. It's 2 weeks for every percentage point, so they have to make it really complicated. So if you're 5% permanent partially impaired, you get 10 percentage points. Each percentage point is worth your average weekly wage rate, but no more than the statewide average weekly wage, which is a much lower number. In 2018, it was $310.67. It is like a damage award, though, because everyone gets them. A lot of employers think if your claimant is back to work and seems to be fine, they won't get an award. And the bureau doctor or claimant's doctor will almost always find something wrong with them and give them a couple percentage points. This is also where claimants' attorneys make most of their money. I think they generally take a third of that. So everybody gets some kind of award. Scheduled loss. This is the loss of use of a body part or an actual amputation. So if a person loses a body part, such as a foot, a hand, in an injury, they'll get a chunk of money for that. There's also something called the loss of use, which is where claimant proves that although I still have my hand, I can't use it at all because my carpal tunnel or whatever it is so severe, I have no use for my hand, then they could get a scheduled loss award under that. And just for example, each body part has a number of weeks, and this goes by the same rate as the TT rate that they can get for a body part. So like for a thumb, a loss of a thumb in a 2018 claim is worth just under $56,000. A leg is $186,000, so these can be really costly. If you have an amputation, that's pretty clear cut. It's hard to win one of those, but if it's a request for a loss of use, that's something that you should definitely fight. Permanent total disability compensation is like the holy grail of workers' compensation. This is when a person proves that they're unable to engage in any sustained remunerative employment. Not that they can't go back to their old job. They can't do any work at all due to the allowed conditions in the claim. If somebody gets permanent total disability compensation, they get that TT rate until they die, or until, on rare occasions, if a person is trying to work and receive permanent total, or if you find out there's some kind of fraud, you can get permanent total cut off. But generally, that's until for the rest of their life. So that can be very costly. Okay, I'm going to go over the hearing process a little bit. Looks like we have about 15 minutes left. If you have questions, even if they're off topic, let me know. Compensation involves administrative hearings. Kind of like if you haven't been to a workers' compensation hearing, if you've been to an unemployment hearing, it's very similar. Unemployment hearings a lot of times are over the phone. These are in person, but it's the same kind of process. Generally, the Bureau of Workers' Compensation processes claims. There's two agencies involved. And the Industrial Commission is like the court. That's the office that hears disputed issues and makes an order. The Bureau is always the one who processes checks, sets up exams, that kind of thing. All the Industrial Commission does is hear disputed issues and make a decision. And the vast majority of my job is taking these hearings and getting ready for the hearings, advising whether we should take things to hearings, that kind of thing. Okay, again, I kind of went over this. State-funded and self-insured. State-funded employer does not directly pay claims. They pay premiums to the Bureau of Workers' Compensation. Self-insured comes directly from the employer's pocket and has direct impact on their bottom line. There's 3 levels of hearing. First level is the district hearing officer. Hearings are generally 15 minutes, but you can ask for more time and they'll give it to you. If you have kind of a complicated issue, you can ask for 30 minutes, 45, an hour. Generally, they'll give it to you. It's informal. You're sitting at almost like a boardroom table. The hearing officer's at the end, raised up just a little bit, and you have the claimant and their attorney on one side, the company rep, if there is one, and their attorney on the other side. There's SHO is the second level, which is kind of a repeat of the DHO, and then there's the Industrial Commission, which I'll explain more in the upcoming slide. So the DHO, District Hearing Officer, takes place in locations throughout Ohio. The hearing's held closest to where the employee lives, not closest to where the workplace is. So sometimes you're going to weird places. Just got a question. Question is, if you're disputing a claim that the DHO, SHO, or IC, is an attorney required to be present, or can the company delegate argue the case? A non-lawyer cannot really argue a case. A non-lawyer can take their own hearing, and third-party administrators often take the hearings, but they cannot question witnesses. They cannot argue law. They can refer the hearing officer to documents. They can read documents and, ask the hearing officer to look at specific things, but they could not argue something like coming and going. You could not, as a company rep, go to a hearing and argue this is precluded by the company and going rule because that's a legal issue. And of course, you can't question the claimant about what they were doing that day or their treatment. You need a lawyer for that. Good question. District hearing. Both parties present their evidence, witness statements, medical evidence. The administrative hearings are different than court because you don't have to have, the rules of evidence don't apply, so I can bring in a statement signed by somebody and that's considered good evidence. In court, you have to authenticate it and prove who authored it, where it came from. There's no objections in the hearing generally. The hearing officer makes the decision within 7 days and bases their decision on the evidence. I touched on this earlier. The law is liberally interpreted in favor of the injured worker. So if you don't like the district hearing officer decision, you can appeal it, and you have an SHO hearing, staff level hearing, staff hearing officer. And it's basically a repeat of the district hearing officer hearing. The one thing to be careful of, though, is temporary total disability compensation is payable after the district hearing officer hearing. Everything else isn't paid until after the SHO. Sometimes I tell people that DHO is kind of practice, but if the issue is temporary total, the injured worker will get paid if you lose the district hearing officer hearing. Procedure is the same. SHO makes the decision within 7 days of the hearing. Very quick. If you don't like the SHO decision, you can appeal that. And the appeal is just an online document you fill out. It's pretty simple. You have 14 days to appeal decisions, except for permanent partials, 10 days. For some reason, they make that distinction, and that is a hard deadline. There's really no getting around it if you miss an appeal. So if you appeal the SHO decision, you don't necessarily get another hearing, and usually there is no hearing. The Industrial Commission has the discretion about whether to hear this a third time. The Industrial Commission is a body of 3 people that sit in Columbus. There's an employer rep, a public rep, and an injured worker rep. And if you get a third level hearing, and it's usually only if they think there's a somehow juicy issue, you'll have a hearing in Columbus in front of these 3 people. Sometimes they can delegate. They'll say you'll have a delegate hearing, which is just in front of another SHO. So you could have the same issue go to hearing 3 times, generally 2, almost always 2. If they accept your issue for hearing, you'll have one within 45 days. Usually, 95% of the time, maybe even more, when you appeal your SHO order, you'll get a decision from the Industrial Commission that says we refuse to hear this issue, and it's final. The administrative hearings are pretty informal. Rules of evidence don't apply. I'm not going to be standing up and yelling objection. It's pretty casual, informal, but serious. The time constraints mandate brevity. most of the hearing officers are pretty serious about making sure you stay on time. So if I have a 15-minute hearing, I'm going to have about 7.5 minutes to talk, and that's firm, which is why I talk so fast generally. I'm used to speaking very quickly in the hearings. They're not on the record. That's the distinction between unemployment hearings. There's no recording of workers' comp hearings unless you bring your own court reporter, or the other side does. And you can bring your court reporter, you just have to put the commission on notice, and I can't remember, I think it's 7 days, it used to be 14, but you have to give them sufficient notice that you plan to bring your court reporter. Usually you want to ask for extra time, just so if the court reporter interrupts you or whatever, you have extra time to make your argument. Appeals are de novo. That just means it's a brand new hearing. The decision at the prior level doesn't matter. The hearing officer is going to hear everything in you. Evidence can be in the form of live testimony. Medical reports are important. Other documentary or audiovisual evidence. Sometimes we have a video of the actual injury that we'll bring, or a lot of times we'll have a video of the job duties. If it's something like carpal tunnel or maybe impingement syndrome, where we're trying to show this job wouldn't have caused that injury. This is what they're doing. Look how light duty it is. That's kind of a common one. Okay, so beyond the commission, if you don't like your decision at the industrial commission, let's say your claim gets allowed and you don't think it should have been allowed, there's a couple avenues. If it does not involve the extended disability, and what this means is the extended, well, most cases, if it's an allowance issue, it goes to common pleas court. You can appeal to the common pleas court. You have 60 days. Extended disability means everything but the allowance. So if your dispute is whether you think this person should have surgery, or if permanent total disability compensation was granted and you don't think it should have, and you want to appeal that, that's what's termed extended disability. A loss of use award, if somebody gets a large loss of use award for loss of the hand or the leg or something, and you want to dispute that, that's called an extended disability, and that goes right to the 10th District Court of Appeals on mandamus. It's a different avenue. So if it's the allowance of the claim or request for an additional condition, you can appeal to court, and it's just like any other court case. It's a new case. You can have a jury trial. The only issue is whether or not the claim should be allowed or additionally allowed for additional conditions. There, the civil rules of procedure and rules of evidence do apply. You'll have a complaint, an answer, just like any other court case, pleadings, motions, depositions, all that stuff. Physical examinations, you can have the claimant examined by your doctor in court as well. And you can have other kinds of experts. And obviously, it lasts longer than 15 minutes. It's a longer process. So I talked about what extent of disability was, a treatment or compensation issue. You can appeal that on mandamus, but it's a little different. You take the decision of the commission, and you can make an argument to the 10th District Court of Appeals, file an appeal arguing why you think the decision was wrong. But it's not a new court procedure where you have witnesses in a jury trial. It's a formal oral argument. Okay, so I'm going to go through some scenarios and talk about whether or not they're compensable. Again, if you have questions, please let me know. Slip and fall at a conference. Generally, an injury at a conference would be compensable. It just depends. If they're just walking down the hallway, they have a bad knee, and their knee gives out, and it has nothing to do with the conditions at the conference, and that's not a good claim. If they fall, though, on water or some kind of condition at the conference, then that would be a good claim. On the way to Wendy's for lunch, talked about this a little bit. If you're on a break, you're off-site. I think even if it's a paid-for break, if you're not on company property, that's not going to be compensable. Fight or horseplay, generally not compensable. The rule for fights, and I've actually seen quite a few of these, in order to have a fight that's payable under workers' comp, the subject of the fight has to be work-related, and the person cannot be the instigator. So if the claimant threw the first punch or started it with words, then it shouldn't be a good claim. And even if they weren't the instigator, but the subject was something totally not work-related, like two men fighting over a woman, something like that, then that should not be a good claim. That's a personal issue they were fighting about. So sometimes we go to these hearings and the whole issue is what the subject of the fight was, and a lot of times that stuff can kind of run together, whether it's work-related or personal stuff. Okay, we see this a lot. Someone having a bad back for years, they bend over to pick up something and have sudden onset of symptoms. It's a common misconception. Usually this one's going to be allowed. Because even though they have a prior bad back, you can always have a new brain strain if you're picking something up. What's different is if somebody, maybe if they only bent very slightly and didn't actually touch something, you could argue that was something like idiopathic. But generally, if you're bending to do something for work and you hurt yourself, even if you have a prior bad back, you're going to see it allowed for something like a back strain, but you probably won't see it allowed for something more serious if there was something pre-existing. So if you have a pre-existing herniated disc, I wouldn't expect it to be allowed for the herniated disc because that existed before. But it could be a new low back strain, and you could see some chiropractic and time off work and all that stuff. In the olden days, before 2006, claimant could say, now my herniated disc hurts more than it did the day before, and you'd be on the hook for the whole herniated disc and everything that goes with that. Now it's a little harder to get that in. Aggravation of pre-existing disease, generally not compensable. It's kind of a weird nuance. You can't aggravate a pre-existing disease. So there's an old hearing loss case. I think the guy was in the Army and suffered hearing loss, and then he worked in a factory and his hearing loss got worse. The court said you can't have an aggravation of pre-existing disease. You can aggravate a pre-existing injury, not a disease in Ohio. Is a specific incident required to have a valid claim? The answer is no. This is called a village case. This is classic wear and tear, usually seen when somebody is, maybe they're doing the same job lifting over the course of a week. It could be months, years. Carpal tunnel is generally wear and tear. That can be a good claim. It doesn't have to be something that happened all of a sudden in an instant. It could be something that occurred over time. Fainting is usually idiopathic. That is usually something personal to the claimant and would not be covered. The exception would be if there was something in the environment at work, like heat or a chemical that caused them to faint. That's workers' comp related. And the other exception is if when they're falling down, they hit something, usually factory equipment, something like that, that causes injury, that would make it compensable. If they just fall on the carpet and it's because they have a history of syncope or something like that, shouldn't be a good claim. Walking up steps and feel knee pop, generally not compensable. Usually that's idiopathic, personal to them. The difference for some reason is if they're carrying something related to work, that usually makes it compensable. I had someone argue recently that the stairs were not standard, that they were an inch shorter than they're supposed to or taller. I'm not sure which one, but that still wasn't compensable. I tried to make a distinction. And what the claim is trying to do is say there was a specific hazard of the employment that makes it different than my everyday life. That means it should be compensable. We're almost done. Psychological condition, we did talk about that one already. You can't have a standalone psychological condition. Heart attack at work, I talked about that a little bit too. Stress has to be worse than normal stress. And if you look at the case law, I've only found one case where a heart attack was compensable. It was a firefighter that all of a sudden had worse job duties. Generally, heart attacks at work are not compensable if it's due to stress. Usually that's just something personal to the person. They would have had a heart attack if they were at home or at work. Injured at company picnic, this is the waiver we talked about earlier. As long as the person signs a waiver, they won't be able to file a workers' compensation claim after an injury. Drugs and alcohol we talked about as well. Generally, drugs, and if the person is impaired due to drugs or alcohol, it's not a work-related condition and it's not compensable. Hour's up, right? It's an hour. If you have any other questions, please let us know. We got a couple questions, people asking if we can send the handouts. We usually do that. So that's no problem. We'll send that out. Thank you, everybody. Lots of good questions.